The issues we'll look at today are the different types of art sales. I don't mean categories of art itself, I just mean different environments of the sales and the different art market roles and mores. And it's useful to understand a little bit about that because they govern the sort of behaviour and expectations of the counterparties. We're looking at some common issues in art sales that you ought to be aware of and your client ought to be aware of, and particularly, obviously, legal and art due diligence, two overlapping but slightly different things. We'll look briefly at private treaty sales, how they work, and also obviously selling and buying at auction. And then throughout, obviously, these issues of attribution and authenticity will come up. So we will finish off with some of the case law in those areas. So common issues for all art transactions, particularly in the second market, identification and attribution of the art. We will look at that. Issues of valuation and, for that matter, of condition of the work of art are very important. We'll look at those very, very briefly. Ownership and title, obviously. Roles and relationships, we talked about that a little bit just now with agency, authority, who is doing what for whom, disclosure, transparency, all these issues feed into that area. As lawyers, we're particularly it's particularly important that we look at matters of payment and transfer of title, transfer of possession, and transfer of risk. And those three things may happen at the same time, but they may not. And whatever type of contract your client is entering into should be very clear about all those three issues.